In the matter of the state of Goa versus NAMITA Tripathi, Supreme Court allowed the appeal and set aside the order of the High Court. Consequence would be that complaint filed by appellants along with order issuing process of 4 December 2019 would stand restored to the file of learned JMFC Panaji and shall be proceeded with in accordance with law. Pursuant to inspection conducted on 20 May 2019 in premises of respondent wherein business of professional laundry service was carried on, it was found that the respondent did not possess factory approved plans as required under Rule 3 of Goa Factory Rules 1985. Read with Section 6 of the Act of 1948 that the premises were being used as a factory without obtaining valid factory license in violation of Rule 4 of the rules read with Section 6 of the Act of 1948, and that the respondent had not submitted any application for registration and grant of license in violation of Rule 6 of the rules read with Section 6 of the Act of 1948. An inspection report was drawn up and the same was furnished by a covering letter dated 24 May 2019 with the occupier of respondent to report compliance within 15 days. The inspection report set out at the time of inspection there were more than 9 workers employed, that there was no muster roll maintained for month of May 2019, and manufacturing process of cleaning and washing of clothes was carried on. Report set out details of machinery and equipments and the total installed power, and set out that the premises amounting to factory within the purview of Section 2M1 of the Act of 1948, and also observed about the violation as set out with regard to absence of registration and license for use of premises as factory. Occupier was advised to submit an application for due compliance of act, failing which they were warned that it will constitute criminal offence punishable under Act of 1948. Complaint alleged that by letter of 30 May 2019 signed by authorized signatory of respondent, reply was furnished setting out that respondent who operated under the name and style of White Cloud is a professionally set up laundry comprising of 6 collection centers around Goa and one central processing unit. That it had 58 employees in collection center, including 10 workers at central processing unit. That a similar inspection had been carried out in 2005 and no further action was taken. That under Act of 1948, washing and dry cleaning would not constitute manufacturing process. The laundry business is a service and not a manufacturing activity, since the product of the business is intangible. That what is rendered is a service and they are duly registered under Shops and Establishments Act. Supreme Court said that the verdicts in complaint alleged that respondent had violated provisions of Act of 1948 in as much as being a factory they have not complied with provisions of Act of 1948 on matters herein above. Position is disputed by respondent on ground that premises do not constitute a factory as defined in Act. To answer this question, examination of scheme of Act of 1948 with particular focus on definition of factory under Section 2M as well as of manufacturing process under 2K is essential. Reverting to the statutory provision, it is clear on plain reading of Section 2K of Act of 1948 that washing or cleaning of any article or substance with a view to its delivery is clearly covered by the phrase manufacturing process. Where the words of statute are clear, the plain meaning has to be given effect. We have no doubt, Supreme Court said, in our mind that the business of laundry carried on by respondent involving cleaning and washing of clothes, including dry cleaning, would be securely covered by expression manufacturing process. Admittedly, they employed more than 9 workers in centralized processing unit and also used the aid of power. It is very clear that Section 2G of 1934 Act did not have the words washing, cleaning, and they have been specifically brought in the Act of 1948 with the clear object of bringing into fold of Act undertakings excluded from the scope of 1934 Act as discussed in statements and objects and reasons. In order to properly interpret any statute, it is necessary now, as it was when Lord Coke reported Haydon's case, to consider how the law stood when the statute to be construed was passed, and that's what the mischief was for which the old law did not provide, and the remedy provided by the statute to cure that mischief. The reasoning of High Court that a transformation has to ensue, a new article must come into being, and it should be commercially known as another and different article is a totally erroneous finding. High Court has clearly ignored plain language of section and has been completely oblivious about welfare nature of statute. The High Court has extrapolated definition of manufacture as in vogue in the Central Excise Act 1944, where statute under consideration itself defines for purposes of said act a certain phrase. Court of law is bound to apply the term as defined except in exceptional cases where opening part of definition anything repugnant in the subject or context applies. Supreme Court said that Act of 1948 defines manufacturing process, and we clearly find that washing, cleaning, and the activities carried out by respondent with a view to its use, delivery, or disposal are squarely attracted. Contention of respondent that dry cleaning does not make any product usable, saleable, or worthy of transport, delivery, or disposal has only to be stated to be rejected. Manufacturing process has been thus defined to mean any process for washing or cleaning with a view to its use, stale, sale, transport, delivery, or disposal. Linen deposited with the launderer is after washing and cleaning delivered to customer for use. Ingredients of the sections are fully satisfied. There is nothing in Act of 1948 which is repugnant in the subject or context, constraining us to jettison the definition. Hence, we reject Supreme Court said the findings of the High Court and held that the activity carried out, which on facts is not disputed, is clearly covered by the definition of manufacturing process under Section 2K, which in turn would bring premises in question of the respondent under definition of factory under Section 2M. Supreme Court said the High Court has been carried away by the holding of Punjab and Rana High Court in triplex dry cleaners case. The said case has no application for the following reason. Firstly, the case was under the Employees State Insurance Corporation Act, and that too before definition of manufacturing process as defined in Act of 1948 was incorporated in the ESIC Act. The definition under the ESIC Act prior to 1989 merely defined a factory. One additional factor to be noticed in this case was that the respondent is registered as a factory under the ESIC Act for the same premises. We have, however, not gone by the mere factum of registration, said Supreme Court, but have independently arrived at the above conclusion based on interpretation of provisions of the Act of 1948.